The final panelist for panel 1 is Samuel Levine from Touro Law Center.
For decades, the United States Supreme Court has declared that courts are precluded under what I refer to as the hands-off approach from evaluating and assessing the accuracy of the substantive religious claims regarding an individual's religious practices or beliefs. This approach has been subject to substantial criticism by myself and many who are participating in today's event. This issue arose, and some of the limitations on the court's approach were apparent in three categories of cases decided during the first 6 months of the coronavirus pandemic. First, Little Sisters of the Poor, the United States Supreme Court case, in which the court returned to the ACA litigation, to the contraceptive mandate. And once again, we see the same justices, Justice Alito and Justice Ginsburg, replaying some of the debates over the hands-off approach that had taken place in previous cases. Justice Alito insisting that courts must accept the substantial burden analysis as the religious claimants sincerely understand them, while Justice Ginsburg, similar to her approach in previous cases, expressed a willingness to make the statement to conclude that certain provisions do not impinge on the employer's religious beliefs, even when the religious claimants state that they do. In doing so, Justice Ginsburg again seemed to have expressed and demonstrated a willingness to defy basic aspects of the hands-off approach. A similar issue arose in the OLG case, likewise decided in July of this year, where the majority held in favor of the ministerial exception. In fact, the Supreme Court in Hosanna Tabor had unanimously adopted the ministerial exception. However, Justice Thomas, in the concurrence in OLG, expressed a highly deferential approach, concluding that the courts must defer to the good faith claims that a certain employee's position is ministerial within an organization, where Justice Sotomayor, this time dissenting, found that to be overly differential, and again, in a way that calls into question this hands-off approach, concluded that the court, or argued that the court, was all but abandoning judicial review. Finally, the cases that have been addressed by previous panelists regarding the religious gatherings. And without commenting on the conclusions that the other panelists have reached in terms of the merits of the case, I wanted to flag Judge Easterbrook's opinion for the Seventh Circuit, where he stated churches can feed the spirit in other ways, and therefore the services did not have to be held in person, seeming to pass judgment as a judge on the religious claimants' beliefs, whereas the Sixth Circuit, for example, made it very clear in their view, applying the deferential hands-off approach, that's exactly what federal courts are not to judge, how individuals comply with their own faith as they see it. So these cases demonstrate once again some of the applications and limitations and problems with the United States Supreme Court's hands-off approach.